Seamone. And I'm not going to delay it, but I think that one of the big lessons from the first session on Tuesday is just how complicated and how sometimes contradictory this process is. And fortunately, Major Seamone has offered to be available to us as technical assistance consultant. So for those of you who please submit questions, but also with follow-up questions, I think that this will be a very helpful resource. So thank you, Major Seamone. So I'm going to turn this over to Kerwin now.
Thank you, Carolyn, and good afternoon or good morning, everyone. My name is Kerwin Henderson. I'm a research specialist here, Justice Programs Office at American University. And on behalf of our office and Major Seamone and everyone here, thank you for joining us. For those of you that missed the first session should be posted on our website shortly. We'll be sending also a link out on our webinar. For those people that you have, those colleagues of yours that you have that may not be able to have not been able to attend this session, we'll also send a link out and have this session posted on our website also. I know Major Seamone has a lot to cover, including a questionnaire that he wants to dig into and discuss, just with some applied examples to build off of what he discussed in the first session. So without much further ado, I will hand it over to Major Seamone.
All right, thank you so much. And everyone who's returned, I want to thank you for bearing with this process. I think it was really important for us to get into the variety of just general considerations before we try to go into specifics. And certainly the time constraints we have really do limit what we can go into. So if we think about, again, emphasizing the fact that I'm not representing the Department of Veterans Affairs, Department of Justice, military, and again, providing only personal perspectives from experience, I think we're really going to be applying today our 3 missions, which were after just understanding how many people might actually be affected by this problem of stigmatizing discharges that are limiting their ability to obtain the VA benefits. So now we're really going to apply the general lessons we learned to understand how to address individuals with their own unique circumstances appearing on a Veterans Treatment Court docket. So I want to emphasize that I hope it's available for your review. If you wanted to download it, I'll definitely walk through it, but I've provided you with something that I call a questionnaire for a rough estimate of a Veterans Treatment Court participant's eligibility for VA benefits. And when I say a rough estimate, we need to recall that sometimes even when the planets align and it would seem like there's not a bar to discharge, eligibility, if you have someone with an other than honorable and undesirable or bad conduct discharge, it still could end up being something where a bar is found by the adjudicator. But what we're trying to do is we're trying to identify our populations who may still very well be entitled to benefits, and also to identify those who may not likely be eligible and who will need alternatives because they don't have the full array of VA resources. So it's a rough approach, but it is certainly one that I think could be helpful, and I've embedded some of the considerations we were talking about, like minimum time in service and what happens when you have a reservist or a National Guard member who did not serve on active duty, and how that relates to the minimum time in service. And then we're going to talk about just a couple of realistic hypotheticals to help us think about the considerations, the different considerations. I do want to show you what a DD-214 looks like, and if you have an opportunity to review it, you'll see that on one piece of paper, and it's usually the service member's copy, is the number 4, and that's actually provided either in the mail or physically handed over to the person as they do their final out processing leaving the active duty service or leaving the military. A DD-214 will list the type of discharge, it will list the character of discharge, and when we look over here it says under honorable conditions but general, which tells you that that's a general discharge. It gives you the reason for elimination, and in this case we can see it's 1412 Charlie, which in the Army means that you committed a serious offense and you were discharged on the basis of committing a serious offense, but with a general discharge. And then you also see other types of annotations there. So this is what the VA adjudicators are really looking for to help them make their determinations. Now, while we're thinking about this, and before we get into the first hypothetical scenario, because I want to think about what we should be looking at in all cases, if you do have access to the questionnaire, one of the first things to consider is active duty military service. And I mention that because in Title 38 of the United States Code, Section 5303, capital A, this is where we see something very important. As of September 7th, 1980, Congress changed the law and imposed a minimum time of active duty service requirement. One of the problems, and remember 1980, we have lots of returning Vietnam veterans back in the community applying for VA benefits. The concern was that some people who served in the military were trying to get out early just so they could collect VA benefits. And Congress became concerned, and they were very interested that people either served a minimum time on active duty before they'd become eligible, or that they completed 24 months of service. If they did not complete their full term, it was at least 24 months or 2 years of active service. Now, if we're talking about September 7th and before 1980, so someone who enlisted before September 7th, 1980, or on September 7th, 1980, then there's really no minimum active duty requirement. However, if we look to those who enlisted on September 8th, 1980, or after that, there is a requirement for either 24 continuous months of active duty service or completion of your full period of enlistment. Now, because we have misconduct as the basis of a lot of these involuntary separations, I think it's more likely that someone with an OTH or another stigmatizing discharge is not going to have completed their full term of enlistment, so you're really looking for the 24 months. So what we ask is which branch did you serve in on active duty? And we're only concerned first with active duty, and the idea is that I don't know how many commissioned officers of the Public Health Service or National Oceanic and Atmospheric Administration end up in Veterans Treatment Courts, but they very well may also be entitled to these VA benefits. So you're asking, did you serve your full period of enlistment when you were on active duty? And that's a helpful question to ask, because if they did, then it's likely that if they served their full time or they served more than 24 months and they fall into that category, then they meet the active duty and minimum service requirements. Were you discharged for any reason besides completion of your contractual term? They could say misconduct. They could say it was if they say it was a hardship discharge or a medical discharge, those can be important exceptions where even though you didn't meet the maximum, the minimum time frame, you still may have the ability to qualify. And then the question to ask after that is, did you complete more than one period of enlistment. In other words, did you re-enlist at any period during your service? There is an official precedent opinion from the VA General Counsel from 1991. It's number 6191 that lays out the rules which say that if you have a prior term where you were honorably discharged and then you're in subsequent misconduct and involuntarily separated in a later term, you still get benefits related to the first term. And I can definitely send that out and provide that to you because you want to have a copy of that first honorable discharge to see if you can base the benefits strictly off of that. And then if you were discharged prior to your term of enlistment, how much continuous time did you spend on active duty? How many DD-214 forms were you given? Do you still have any of them? Now, one of the important things that I want to talk about is, and we're going to see this in a hypothetical, what happens when the person who's in your docket making an initial appearance says, I'm a veteran, but I don't have my DD-214, or maybe a comment like, it's in the mail. They told me it was in the mail, but I never got it, and they just wanted me out of it. So I don't know what my discharge characterization is. There is a traditional process. There's also a website. You can use the form SF-180 to try to request military records. And for DD-214s, the general processing time is about 10 days, but that can vary. However, if you need to make an immediate determination, there may be another alternative for you, which I'm going to talk about later, which is called the Veterans Research Search Services. And that was created in 2012 as a way for, it was actually very much used by healthcare reentry for veterans, the VA employees who would go into prisons and jails to counsel inmates on VA benefits. And this program does a computer matching with social security numbers, and if you provide other information related to the person, they can very quickly identify if that individual is a veteran and what kind of discharge characterization they have. They create a report that goes to the VA professional that can be used by court personnel. And we'll talk about how to get there. And I highly encourage that if you aren't using it, this is a program worth investigating to help make some of these determinations easier and to see if you can start pushing for tentative eligibility if someone's available for that, or expedited services with this information. Now, the question is, do you have your military records? Sadly, if someone has an OTH or a BCD, a lot is going to depend on the nature of their misconduct. To find out whether there's a statutory or regulatory bar, you often might have to have copies of the separation proceedings. So if it was an administrative board, you want to get a ruling of the board members and the nature of the discharge that they adjudicated and what they based it on. If it's a court-martial, you probably want to get the promulgating order, which is something created after the conviction and the sentencing. And you also might want to get the transcript. You want to determine if there were charges that were dismissed, because if you had a morally turpitudinous charge like theft or larceny or fraud, and the person was found not guilty on that charge, it's good to know that, because that could take a bar off of the table and allow someone to get benefits based on what they were actually convicted of. So a lot of times it requires more than the DD-214. It requires the actual paperwork, and that takes far more than 10 days. It can take months to get court-martial records, and they might not even be complete. So you're trying to, I think, when you're using this questionnaire, or if you want to create your own, identify which are the easiest battles, which ones are pretty clean cut. If it's under honorable conditions, it should be binding on the VA, so that's far less of a concern than if you get into these other than honorables, undesirables, and punitive discharges. Now, for reserve duty, it's pretty much a different rule. You know, you could have someone who goes to drill on the weekends, like one weekend a month, and then they do annual training. And this active duty requirement actually applies to them. So we care about when they were mobilized on Title X orders, because that's putting them under federal mobilized authority that applies to active duty service members. We are looking to see whether they completed their full term of mobilization or whether they served for 24 months during the course of a mobilization if they didn't complete their full mobilization. And we'll look at a few examples, but if you had someone who was only doing drills and never really was put on active duty orders and didn't really serve that long on active duty orders or didn't meet the full time, it's going to be very difficult to get them benefits. One exception is if they were during the line of duty, if they were actually in inactive service, maybe attending drill, doing something related to their duties, and they were injured and it was ruled to be in the line of duty, then they can still get benefits. But there's a lot of concern over that. So ask about the reserves, ask separately about the National Guard, ask about mobilizations. Question 4 there is, for all of the times you were mobilized, did you complete the full term of your mobilization? That starts to indicate that they probably do meet the minimum service requirement. If any mobilization was cut short, please list the reason why. Do you now have an injury that you sustained while on a regular non-active status? So you weren't mobilized, but you were injured, and where you want to look for that is 38, Title 38 of the Code of Federal Regulations, Section 3.6, capital A, is what governs this. Do you know whether a line of duty determination was made regarding the injuries sustained on non-active duty status? Line of duty investigations at the military level look to see whether a person was injured based on their own willful conduct or some kind of misconduct, or if they were really not at fault. And so you know, if someone's drinking alcohol and they get into an accident and they're injured, even though they're injured, they were drunk, that might be something that for them to rule out that it was in the line of duty, because their accident was in part due to their failure to adhere to the rules. So that's what a line of duty determination might be. Another big issue where this comes up is someone who's on leave, who gets injured. That if they have a leave slip, that means the military authorized it, but if they wanted to travel without authorization and get injured, that can be oftentimes found not to be in the line of duty. And I want to switch now to the less than honorable discharges, and the ones we care about again are undesirables, other than honorables, bad conduct discharges, dishonorable discharges, and dismissals. If you have a less than honorable discharge in any of these categories, do you have a DD-214 for the period of service with either an honorable discharge or a general discharge listed on it? That's the big question to ask, and that's what you want to see. After that, if you have more than one DD-214 with an honorable or general, did your injury or the start of your mental health condition happen during the honorable term or the other term? And we know from VA Precedent Opinion 61-91 that as long as the injuries relate to the prior honorable term, they're covered. But if the injuries relate to the term that is stigmatizing, then the question becomes, do they fall under a bar or not? So different concerns arise. For a bad conduct discharge, what level of court-martial did it come from? Was it a general court-martial or a special court-martial? We know from the statutory bar in 38 U.S.C. section 5303 little a, we know that anything coming from a general court-martial is going to be a statutory bar to benefits. So the service member might not remember. I don't know. It was a court-martial. There was a jury of military members. I know I got a BCD. I don't recall. You may want to kind of just examine that situation a bit more by asking, did you have an Article 32 preliminary hearing? Do you remember anything about that? Because that might suggest that it was a general court-martial. An Article 32 hearing is equivalent. It's something similar to a grand jury investigation in order to be able to go for charges with imprisonment over a year. And just because someone has an Article 32, that doesn't mean that the commanding general sent the court-martial to a general court-martial, but it might be more likely that a general court-martial was possible and that BCD could have come from a general court-martial. If the service member says, I was sentenced to 2 years confinement, that would suggest that it was a general court-martial because of the maximum time of confinement going over a year. The next question to ask is, for bad conduct discharge from a special court-martial, what were the charges that you were found guilty of? And here's where we want to see if it was either a crime of moral turpitude or a crime, or series of crimes involving willful and persistent misconduct. And again, those are in the Code of Federal Regulations because they're regulatory bars. Aside from your conviction, did you have any non-judicial punishment, or were you counseled for other violations of the Uniform Code of Military Justice? That question is basically, okay, we might have a BCD, but do we also have other misconduct that wasn't at the court-martial that can be considered to be willful and persistent? So that's concerning. And for an other than honorable discharge, was it based on absence without leave for a continuous period of 180 days or more? That kicks into the statutory bar in Title 38 of the United States Code, Section 5303 little a. And of course, there's an exception for compelling circumstances, but if you've got someone with over 180 day AWOL or 180 days, it's going to be hard to show this exception applies. And then one of the things I included in this form is some references for you for alternatives to help get immediate treatment, even if a person is not likely to be eligible for VA benefits, or if they're going to be requesting personnel records that could take months or longer to obtain. But one of the things I want to tell you is that your state departments of Veterans Affairs are organizations that are developed through the state to help veterans get benefits, help them help alleviate many of the concerns they have. Now, I will tell you that many of them condition those services on an honorable discharge or a discharge under honorable conditions. But it's still worthwhile to see what's out there from the state, and if there are any specific alternatives that they provide for treatment that are not linked to the federal VA. It is worth evaluating that, and I've provided a link for you to the website where you can find each of the state departments of Veterans Affairs to conduct this kind of exploration. Now, your vet centers are another alternative, and I think they're very important after Vietnam and as part of studies of the problems of readjustment for Vietnam veterans. Vet centers were created to deal with community counseling and to address the problems of combat veterans specifically. And one of the key ideas here was that even if someone would be barred from getting VA benefits, if they had combat service, they would still be able to get some kind of counseling, readjustment counseling, also oftentimes includes family counseling as well. And so the vet centers are an alternative. If you have someone who was in combat, and maybe, I'm sorry, one of the questions for someone with an OTH or a BCD or a dishonorable or a dismissal should be, did you spend any time in combat? Because if so, don't forget that the vet centers can provide veteran-specific treatment to some level. I would not expect psychotropic medications, but I would expect at the very least some kind of group therapy, counseling. So this is definitely an option. It is funded by the VA, but it is a separate entity that is designed to help combat veterans specifically with readjustment issues. Now, veteran service organizations and county veteran service officers are extremely important. They are varied. I know that I've listed a few here. So Iraq and Afghanistan Veterans of America, Swords to Plowshares, the American Legion, AMVETS, etc. You also have the officers within the county who assist people. And the idea here is that these individuals are very experienced with the nuances of these determinations, and sometimes even trying to fight for benefits with regional offices. They will likely know about your own regional office where you are, where your Veterans Court is, trends and ideas on what's successful and how to package a claim to try to get the greatest benefit from it. And so if you haven't established a network or relationships with your county veteran service officers or your veteran service organizations, that really can be tremendous as an alternative. I listed one here. It's a VSO called Vietnam Veterans Against the War. But what's really important about this one is that Ray Parrish is a veteran service officer who worked with some mental health providers to develop a network of providers who were willing to come in and assist with VA benefits evaluations for people who don't have fully honorable discharges, specifically to help them. So you have a list of resources here, and you can try to see if there are different alternatives available to you. I've given you a website for all of the local veterans, county veteran service officers, and then later the veteran service organizations themselves. The fourth option for you is Give an Hour, and this is important, I would say, because it highlights people who are putting themselves out into the community specifically with the goal of helping veterans with veteran-specific treatment issues. Give an Hour was a program developed specifically because there was fear that active duty service members would feel too stigmatized seeking help. And so they wanted to create an alternative where providers in the community who did not answer directly to the military command could actually help these service members with their mental health issues without risking careers or enhancing the stigma. I mentioned Give an Hour because you can use their website to identify providers who are volunteering their time to treat veterans in the local area. Now, while the program is not designed for justice-involved veterans specifically, you've got an audience that I think would be very receptive to the idea that if you have veterans in conflict with the law, maybe they need services in a much more timely manner and they're the most at risk. And certainly if you haven't explored the option of finding these providers who are offering free treatment services, this can be another way to accomplish your goals without fearing a laborious process with the VA that may only lead to more confusion. One other thing I did for you on the bottom of page 6 of this form is I gave you an excerpt from the VHA, that's the Veterans Health Administration Handbook. And even though it's from 2009, this policy is still in effect. And it basically talks about if you have an OTH or a BCD, what's supposed to happen. And I draw your attention to the note. It says if the DD-214 indicates OTH or BCD as the character of discharge, VHA must submit a specific form and request the regional office to take appropriate action to obtain an adjudicated decision. And that's the character of service review process. Eligibility status will be pending verification until a decision is rendered. And I think this really answers the question that was posed, not only in my words, but in the words of the organization that matters most. They're not going to treat it as ineligible. They're going to say, we're waiting to see what happens. So they're not discounting eligibility for benefits until one of these review processes occurs. And there is a very clear authority you can use to raise that point. Now, I do want to emphasize this point, which is if you would like to explore local veterans service organizations and try to sit down with stakeholders to create more alternatives besides standard VA channels, that's something we're here to do as technical consultants, and we can try to arrange something, find people, and discuss some frameworks that would offer more opportunities for you to meet the objectives of your own specific Veterans Treatment Court docket. With this in mind, I'd like to go into our first hypothetical. This is not a real person, but I think sometimes when we see a picture, it becomes more relatable. So this is a person that I'm calling Private Ray Hobson. And let's assume that Ray Hobson entered the military before September 8, 1980. He had an enlistment period for 2 years. During his enlistment, he was deployed to Vietnam. He received a bad conduct discharge at a special court-martial 6 months into his tour. And at the time he was discharged, he served a total of 10 months on active duty out of his 24-month enlistment. The question first is, based on the facts above, and I'd love for you to give some of your thoughts on this, does it matter that he only served 10 months out of a 24-month enlistment period, and why? If you could type in any answers, I'd really appreciate that. Thank you so much. So if we have any thoughts on this, I think the answer is because he entered military service before September 8, 1980, there really isn't any minimum service requirement that he would have. So the fact that he spent only 10 months of his 24-month enlistment period is not necessarily something that would discount him from being a veteran. Does his bad conduct discharge bar him from receiving all VA benefits? And that really focuses on the fact that it was a special court-martial. So the question is it a bar to benefits to have a bad conduct discharge from a special court-martial? And if we consult Title 38 of the United States Code, Section 5303A, what we'll see is it is not a bar to benefits just to have a BCD from a special court-martial. It's only the general court-martial that is statutory bar. So right now, I don't see a statutory bar. At the time he was, so if we go down to the next question, what if it was a special court-martial? Actually, what if he received a bad conduct discharge from a general court-martial? I think the answer there is that he would be barred from benefits because then he falls within the statute that says any kind of discharge from a general court-martial is a statutory bar. But if it was a special court-martial and the crime was the larceny of a Jeep, we don't have the statutory bar for a discharge coming from a general court-martial, but the problem there would be one of the few very clear moral turpitude bars for the regulatory bar of moral turpitude is larceny, theft, fraud, any kind of crime like that has already been deemed to be a crime of moral turpitude. So he would likely be barred on that regulatory basis of having committed a crime of moral turpitude that led to his discharge. Instead of a crime involving stealing a Jeep, if it was assault of a senior non-commissioned officer, that probably isn't morally turpitudinous, and that would probably be a good contender for someone who might not be barred from benefits. If the only thing was a BCD from a special court-martial for the non-turpitudinous crime of assault, that would probably be a good contender for some kind of benefit eligibility. And then the final question here is, what if this guy had a prior special court-martial in addition to the one that led to his discharge for assault? Suppose he was not kicked out of the military, so it is possible to have a court-martial and be retained. So you just have federal convictions, but you don't get kicked out of the military. If this was the case and he was retained, but was convicted for sleeping on guard duty 8 months into his tour and 35 days of absence without leave 6 months into his service, is there any significance to that event? And the answer to that question is probably yes, because we see different incidents. We have an AWOL, which the Board of Veterans Appeals likes to consider to be willful and persistent misconduct because it substantially interferes with the performance of your duties. So when you have just a court-martial from a special court-martial and it's just a bad conduct discharge, that's not too threatening. That sounds good if it's not moral turpitude. But if you start adding other offenses that can be considered in different time frames within that term of service, you could very likely still have a bar based on willful and persistent misconduct. So these are all considerations to think about. Something in the actual handouts and materials I provided before, but it's worth emphasizing here, and this is something to note. Anyone with a bad conduct discharge is barred to health care benefits from the VA. And that's from a public law in 1977. And if you wanted to look this up, it's Title 38 of the Code of Federal Regulations, Section 3.360B, small b, lowercase b. And so what we see here is a bar based on a bad conduct discharge will stop health care. Would it stop vocational rehabilitation? No. Would it stop the ability to get disability compensation? No. We're only talking about health care. So even though someone with a BCD faces many hurdles in health care, if it's not identified as health care and they're found to be under conditions other than dishonorable, then they can still get something, and they still may be entitled to a lot of different benefits. So please keep that in mind for anyone with a BCD. Now, I would like to move to the next slide. Actually, let's move back. So this is Private Lisa Carpenter. She enlisted in the Virginia Army National Guard on December 9, 2003. In 2004, she was put on active duty orders to deploy to Afghanistan. This was a deployment that lasted, that included 3 months of training stateside and 12 months in Afghanistan. And after 9 months, she was administratively separated with an under other than honorable conditions discharge. And the crime was violating a general order that prohibited unlawful cohabitation, which is basically if you enter the housing trailer of someone of the opposite sex, you're in violation of a general order. And that's a very common offense in deployed environments. So when we look at this, We know that she came into the military and enlisted after 1980. So we do have some concerns about minimum service requirements here. First question is, has she met the minimum service requirement to be considered a veteran? And the answer would be, if this is her only time activated, even if we add the time she spent on the training stateside and the deployment, it's not 24 months of continuous service. And unfortunately, it's not a completion of her orders for mobilization, so she would not likely be considered a veteran because of those minimum service requirements. The next question, number 2, is let's suppose that she had no misconduct in Afghanistan and she successfully completed that mission in Afghanistan. But later, in a different deployment in 2006, she had the same misconduct and she was in Iraq this time, and she was terminated before the end of her tour. What kind of considerations apply there? Well, clearly she had a completed term of honorable service from her first deployment in Afghanistan 2 years earlier, so we would be looking to that for her eligibility, even if she would not meet the requirements elsewhere. What if under the same circumstances above, her current mental health condition stems from the second deployment rather than the first? Well, we know that because of these rules, if she had a term that's characterized by an other than honorable, and the service was not complete, then she's going to have problems there, whereas if anything resulted from the term she honorably completed, she would be able to get benefits for the prior term. So our final question here is, assume that it was only one instance, and she needs help and she's barred because she has an OTH and she didn't fully complete the term. What if she said she was sexually assaulted while on duty during that deployment, the one where she got the OTH? Would this change anything regarding her eligibility? And perhaps, again, I did not include it in the form, but it's important to consider, just like we considered, hey, were you a combat veteran? Well, she would be a combat veteran, so she could go to a vet center, even if she wouldn't be eligible for everything. In addition to that, someone who claims to have been sexually assaulted, there's a Veterans Health Administration Directive 2010-33, and it's based on some provisions about specific care related to military sexual assault and trauma. And so the limitation is healthcare will be provided, but usually it's limited only to the military sexual trauma. So if there was PTSD related to combat, then they may not be willing to help there, only the issues relating to military sexual trauma. So MST is worth asking about, even for males, right? Because we're learning that there is a significant number of males in the military who are also, either whether it's hazing or just sexual assault in general, who are also victim to this treatment. So it's worth asking about combat service, and it's worth asking about military sexual trauma, especially for those who would not otherwise be eligible. I'd like to move now to the example of Private Ted Rafans. For Private Rafans, he's saying he joined active duty Marine Corps in 2005 on a 6-year enlistment. He deployed 3 times to Iraq as a sniper. He was involuntarily separated from the Corps after being apprehended by local police based on a deserter warrant. And he was gone for a total of 100 days. He vaguely recalls the process by which he was eliminated and thinks he may have waived his right to a separation board in order to avoid a court-martial. And at the time he was discharged, Rafan served 3 years of his 6-year enlistment. When he was out processed from his unit after his administrative discharge, he vaguely recalls being told to expect a DD-214 in the mail. The documents never came. For the last 2 years, he's believed he's ineligible for any kind of VA benefits, so he hasn't really cared too much about his DD-214 for anything. At this stage, can you estimate the likelihood of Rafon's eligibility for benefits? And the answer is we don't know what his character of discharge was. We don't know whether it was an OTH, a general. It could have been anything. So we really need more information before we can estimate what happened. And the question is there an expeditious way to confirm his time in service? And we'll talk now in a few seconds about more in detail about that VRSS program. If he has an other than honorable conditions discharge, would it make a difference if he was separated based on desertion or absence without leave? And the answer is yes. If you are eliminated from the military based on desertion, and you have an other than honorable based on desertion, you are statutorily barred from benefits. But one key point here is it has to be the basis of being eliminated. So it has to be on that, whatever is linked, the proceeding linked to that discharge has to say it's because of desertion. If it's absence without leave, it's less than 180 days, so you would not have that statutory bar coming into play for the 180-day period of AWOL. So it does make a difference in this particular case. If Rafon's offense is desertion, but he has 2 bronze stars and a Purple Heart, could the VA take that into consideration as mitigation? And we would hope the answer is yes, but that is not built into the system. The VA is not looking to see, oh, what is there to mitigate this? Or we have special things we can consider and avoid imposing the bar. The desertion bar is something in statute, and it does not articulate any exceptions. The 180-day AWOL for an other than honorable does indicate an exception of compelling circumstances, but that's very rarely given. So in a lot of these cases, even though you may have someone who did very heroic things, that may not have the opportunity to grant benefits or weigh in the favor of the former service member. Now, in terms of the SF-180, which is the traditional way of obtaining forms, there is a computerized website where you can request the forms. Sometimes they require something signed and faxed, but you have these traditional routes of obtaining records. I just wanted to show you, you may be using those. The VRSS, this is the website for it. It is a program that is accessible by VA employees, and it is a way to provide the information shown there, which includes a name, social security number, date of birth, gender. With that information, they can conduct a records check where they look at military personnel information that's stored on electronic databases, and they can easily find through a computer match information relating to a specific person. And that's all you need, those key demographic indicators. It was developed in April 25th, 2012. And I'm giving you the example of California because it's a pretty serious and powerful tool. The California prison system used this as a test pilot. They initially had estimated that 2.7% of the population of inmates in prisons had veteran status or had served in the military. And by using the VRSS system, they realized it was actually 7.9% of their inmate population, which really translates to over 5,000 inmates that they did not correctly anticipate were veterans. And that's really a very powerful indicator that A lot of people will not volunteer their veteran status. It will be very hard to identify veteran status. And the beauty of this is not only does it say whether or not that person had military service in the past, it provides details to the VA representative regarding their character of service as well. They don't automatically give that to the judge or the court personnel or the warden, but it is accessible, and it is accessible in a much, much faster way. So I'm interested to know if anyone who's participating here has actually used this system or was aware of it. Certainly it would be beneficial to work with especially the healthcare reentry for veterans personnel, because they probably frequently use this system. Now, I know we've, again, covered a lot of information, but I hope that I've brought a little bit more of a practical perspective to this. And at this time, I'd love to answer any questions you might have.
Doesn't look like we have any questions immediately. I guess we'll wait a little bit longer. But thank you for the information. Thank you for the presentation, Major Seamone. Extremely helpful, and the practical examples that you gave, I'm sure will be extremely informative to those jurisdictions out there that are trying to figure out, what other resources they can tap into. The VA will not treat their justice-involved veterans. So, again, thank you for the presentation. So I guess we'll wait a couple more minutes for any questions. If anyone wants to ask any questions from either the first session or this follow-up session, feel free to go ahead and looks like we got one in. Let's see. Arthur Alarcon says, data presented is very detailed and technical for new members to the Veterans Treatment Court as a mentor. He says it's very good info, however.
It's intimidating to lawyers. It's intimidating to regional office administrators. I appreciate your willingness to think about this. This is not easy because you have so many different regulations in different places, right? You've got the Code of Federal Regulations. The VA has its own internal operating rules to follow, and then you've got the law, the statutes. One of the points is that's why it's vital, to try to reach out to someone who's a veterans service officer who works with claims on a regular basis, and maybe even to try to bring that person, if they're willing to volunteer their time, which most of these individuals are so dedicated and just giving of themselves, they really see how often benefits are denied, and sometimes on arbitrary bases they want to make a change. So I think this is a population that would have an interest, if invited, to actually come and participate in the docket and maybe even meet with those individuals who have stigmatizing discharges and who look into their situations. It's a type of expertise that they've developed over the course of years of dealing with regional offices. And my suggestion is try to use those resources rather than attempting this yourself when it's so hard to grasp and there's so much going on. But having a general idea of what to expect can help you identify populations that need that kind of intensive assistance. I hope that offers something, and again, I'd be more than happy to, depending on where you are, see if someone would be willing to come out there and provide some of that needed guidance and participate if you wanted that.
And this is Carolyn, and I just wanted to stress that it is intimidating. It's so intimidating to even the most seasoned people, let alone the poor veterans who, have no idea how to wade through this stuff. So that's why, please, we're so grateful to Major Seamone for working with us and at least helping provide some guidance. So if you come into situations, feel free to send them on our listserv, and to the extent others can share experience, that's great, and Major Seamone can weigh in at all as well.
So, Major Seamone, it looks like Mr. Alarcon followed up and said that he's a former employee of the Denver RO, and that was a good suggestion. So we have a couple more minutes for any more questions. So if there's any other questions out there, once again, from either this session or the first session, please feel free, or about anything related to Veterans Treatment Course, feel free to ask, please. I want to put her on the spot, but Monica, did you have anything to add or anything to ask?
No, nothing for me to add. We will be sending out the link to today's recording, as well as the PowerPoint slides and the questionnaire that Major Seamone developed, as well as a few other supplemental documents. And we will also have them posted on our website, our Justice Programs Office website as well. Thank you again, Major. Great presentation.
Thank you so much.
And I'd just like to add, too, that Major Seamone will be back. I know we are in talks of holding another seminar upcoming on the use of jail pods for veterans. We're still in the preliminary stages of figuring when that will be, but keep posted to our listserv and spread the word, and keep an eye on our listserv, and we'll send an announcement about that shortly. So. Well, I think that's it for questions. So once again, thank you all for joining us today. And as I said, be on the lookout. We'll be sending some more announcements out about our upcoming webinars with Major Seamone, and also with other consultants. I know we have a webinar coming up on the role of the judge and Veterans Treatment Courts. So be on the lookout for those through our listserv. So thank you all again, and have a great afternoon.